The applicant in this matter stands arraigned on 3 counts of fraud. The first count involves an amount of 174,500 rand. The second count involves an amount of 145,247 rand. The third count involves an amount of 90,999 rand. Because of the amount involved in count number 1 and count number 2 and the fact the applicant has a previous conviction for fraud, the bail application falls under Schedule 5. Schedule 5 bail applications are regulated by Section 60, subsection 11, small b of the Criminal Procedure Act number 51 of 1977. The section I've just referred to enjoins the court to order an accused to be kept in custody unless, after having been afforded an opportunity to do so, he or she adduces evidence which convinces the court on a balance of probabilities the interest of justice permit his or her release on bail. Evidence in the present matter was presented by way of affidavit. On the conclusion of the case for the respondent, Mr. Erasmus, who appeared for the applicant at that stage, submitted. The investigating officers confirmed the applicant will not be in a position to interfere with the state witnesses if bail is granted. He has further submitted the fact that the public is furious about the applicant's conduct is not relevant in determining whether or not bail should be granted. His submission, it is for the court and not for the public to decide whether or not bail should be granted. The prosecution, on the other hand, submitted the onus is on the applicant to convince the court the interest of justice permit his or her release on bail. The state submitted the applicant is a repeat offender. As a result, bail should not be granted. Mr. Morum also submitted he disagreed with the submission. The state case is weak. His submission is the state has an overwhelming evidence against the applicant. He has also argued the submission by the defense that the applicant is suffering from a chronic illness does not carry weight in the light of the fact the defense failed to provide any medical certificate to confirm the applicant has chronic illness. The question is, under what circumstances do we say it is in the interest of justice for the applicant to be released on bail? The situation is regulated by Section 60, subsection 4A to E of the Criminal Procedure Act number 51 of 1977. Section 60, subsection 4A provides it will not be in the interest of justice for the applicant to be released on bail if there is a likelihood, if bail is granted, he or she will endanger state security or commit a Schedule 1 offense. Section 60, subsection 4B provides it will not be in the interest of justice to grant bail to the applicant if there is a likelihood he or she will attempt to evade his or her trial in the event of bail being granted. Section 60, subsection 4C provides it will not be in the interest of justice to grant bail to the applicant if there is a likelihood the applicant will attempt to intimidate or influence witnesses if he or she is released on bail. Section 60, subsection 4D provides it will not be in the interest of justice to grant bail if there is a likelihood, if the applicant is released on bail, he or she will jeopardize the objectives of the criminal justice system. Section 60, subsection 4A provides it will not be in the interest of justice to grant bail to the applicant if the release of the applicant on bail will jeopardize public order. I have to make it very clear the list provided in Section 60, subsection 4A to E is not exhaustive. If there is any factor in existence which is not mentioned in Section 60, subsection 4A to A, which the court is of the view it will not be in the interest of justice as a result of the existence thereof, bail will not be granted. On the conclusion of the applicant and respondent's case, I inquired from the prosecution as to which factor does the prosecution feel the applicant has failed to establish which makes it in the interest of justice not for her to be granted bail. Mr. Maruma indicated to me the state is opposing bail because the applicant is a repeat offender. My understanding, therefore, is that the state is submitting that the factor mentioned in Section 6, subsection 4A of the Criminal Procedure Act number 1977 has not been established by the applicant on a balance of probabilities. In other words, the state's feeling is if the applicant is granted bail, there is a likelihood he will commit a Schedule 1 offense. My understanding is the prosecution is coming up with this submission in the light of their indication the applicant has a previous conviction for fraud, which the application admits. The state has also indicated to me there are 37 other cases of fraud which have been opened against the applicant. On the date the bail application was heard, that was on the 18th of December 2025, it was also brought to my attention by the public prosecutor that while he was with the investigating officer received a call from 3 police officers who stated they wanted to arrest the applicant on that date. To this date, I have not been informed if the arrest has been effected. I will assume they have not been effected. The question is, what does these other documents which have been opened bear on the present bail application? The law is very clear in determining this issue. The court will take into consideration the applicant's profile, that is, the previous conviction and pending cases. It is very clear from the evidence presented that the applicant has never been charged with these 37 cases referred to by the public prosecutor. At this stage, there is no indication he has been charged by the three police officers whom it was indicated they want to arrest on the 18th of December 2025. In the circumstances, I will say the only relevant consideration in this case is the fact that the applicant has a previous conviction for fraud. The docket that has been opened cannot be considered to be pending cases for the simple reason. When we say the applicant has a pending case, we are referring to a case where he has been charged, he has appeared in court, he has either been kept in custody, granted bail, or released on warning in those cases. That situation does not obtain in the present case. As I said, the only relevant consideration is the fact that the applicant has a previous conviction for fraud. In my view, we cannot, on the basis of just one previous conviction, say a person has a propensity to commit offenses. Because if we are talking of a propensity, we are talking of a tendency to do something. If a person has got only one previous conviction, that does not amount to a tendency. In the circumstances, I am of the view there is no evidence which suggests there is a likelihood the applicant will commit a Schedule 1 offense in the event of bail being granted. I am satisfied in the circumstances he is an ideal candidate for bail. Bail is granted. In view of the serious nature of the charges and the amount involved, I have come to a conclusion the appropriate amount of bail will be 100,000 rand. Bail is set at 100,000 rand.
To February, mid-February, February the 18th, to allow police officers in those outstanding matters to charge, even if possible, to arrest the accused person in outstanding matters. 18th February 2026.
Your worship, the date is suitable.
There was the mention of the issue of the passport.
Yes, I remember there was.
I want it to be handed to the prosecution.
Yes, Mr. Erasmus made mention of that passport.
Mr. Munji.
I have the passport.
Yeah, you said it to be handed to the prosecution. Mr. Moruba, you confirm receipt of the passport.
Your Worship, I do confirm the receipt of the passport.
Matter is remanded 18 February 2026 back to court sitting for further investigation in custody paid 100,000 rand to pay at 8:15. We take a 25 minutes.
Court pleases.
All right.
I'm Christian Frank, investment investor.
He was here.
Can I get your name and surname for the article?
Please. He's better, I don't know.
Is it advocate? Okay. And then the judge's name?
Magistrate.